Welcome to another video of Excel Academy, and in this video we will be studying how and why the SEBI is asking for changes to the Companies Act of 2013. So as you know, Vijay Mallya is a very big case which is actually prompting the amendment in many different laws. So Vijay Mallya's case was also because Vijay Mallya was defined and the SEBI was not able to remove him as director. So Vijay Mallya's defense has prompted SEBI to ask for changes to the Companies Act 2013. That is primarily relating to section 167. Before we understand this in detail, please subscribe to Excel Academy, your one-stop solution for CS course. So as you know, because of this, we can say that Vijay Mallya is amending the company law. So what has happened is the SEBI has asked the government to amend the Companies Act so that to make and ensure that a director who is declared by SEBI as a disqualified person should immediately vacate the position of the director. But the problem is in section 167 there is no such provision. So this was mainly because of the case of Vijay Mallya. So he was reluctant to vacate the board even after SEBI has declared him as a disqualified person. Of course, we need to understand that under Companies Act, the office of director becomes vacant if he or she is disqualified by order of the court or tribunal, and there are many other reasons. You can refer 167, all the subsections. But there is no explicit mention that order of the SEBI will be a ground for vacation of the director. So this is a major problem, and SEBI is seeing this as a big hurdle that in future also Vijay Mallya kind of cases can happen. So it's a proposal has been given by SEBI, and SEBI has now proposed that the Companies Act should clearly mention that a person should vacate the office of director if the order of the SEBI says that he or she is disqualified. So this is the request which SEBI has made. So we should understand that the latest development is that officials have said that the finance ministry is in agreement with SEBI on this proposed amendment and has also asked the regulator to get it approved by the board and subsequently forward it to the MCA. So finance ministry has told for SEBI to get it approved by SEBI board and give it to the Ministry of Corporate Affairs. So in its proposal, SEBI has referred to the interim order which it had given on 25th of January 2017, where the SEBI had barred Vijay Mallya and 6 others from holding directorship in any listed company till further directions. But because section 167 did not provide that, they continued to hold the directorship. Next, the SEBI order was followed by a probe into the alleged illegal fund diversions at the United Spirits, which was headed by Vijay Mallya. And also we should understand that later that was sold to the company of Diageo. So Mallya and others were also barred from securities market in the same order which was given on 25th of January 2017. But Mallya did not comply with the order and he did not step down from the directorship, and he was continuing to be director of United Breweries Limited and another listed company for many months. After the SEBI order, Mallya had also criticized SEBI by tweeting. Yes, on Twitter he had criticized SEBI and had said that the allegations of fund diversion were completely baseless and that had alleged that he was target of a witch hunt by SEBI. Of course, after refusing to quit the United Breweries board, Mallya finally has quit the board in August 2017, but that was mainly because of the pressure from the other directors because the company image was suffering. So in the case of United Spirits, he was asked by the new owner, that is Diageo, in April 2015 itself to quit the board for the fund diversion. So explaining the rationale and the reason and the justification for this, for changes in Companies Act, SEBI has said that the fact that Mallya failed to comply with the directions has brought a legal conundrum in respect of whether SEBI has the power to enforce its direction when director refuses to comply with the same. So that is the problem. So SEBI will tell one thing, but then section 167 of Companies Act 2013 does not provide that. Yes, right now the SEBI's direction direction that a person cannot act as director for vacating his or office under directorship is not provided under section 167. Further, section 164, 167, 169 of the Act, which deals with appointment, vacancy and removal of directors, are administered only by the central government through the Ministry of Corporate Affairs. So SEBI does not have powers under these three sections. So SEBI is exactly asking for that. So definitely SEBI is empowered to initiate adjudication proceedings under SEBI Act for non-compliance of the directions which it had given. It can only be penal proceedings for non-compliance, but it cannot be enforcement of the direction. To enforce the direction, we have to amend these sections, especially section 167. So in view of all the problems which are there, SEBI has proposed that there will be a resolution where the amending of the section 167 has been proposed, and it will include order of SEBI as one of the grounds. So as you know, in 167 we have multiple grounds for director to vacate office, like order of NCLT, etc. Along with that, SEBI requested MCA to add one point, order of SEBI also, for vacation of office of a director. So if this happens, SEBI will not only be able to give the order, but it will also be able to enforce it. So that was the new update relating to SEBI asking for amendment to the Companies Act section 167. For more such videos and all information of Company Secretary course and company law, please subscribe to Excel Academy, your one-stop solution for CS course.